Good morning and welcome to Cheche, the show where opinion counts, live on Citizen TV. I'm your host, Udwa Kamimo. Today's guest is the minority leader in the Senate, Ford Kenya Party Chairman, Senator Moses Wetangula of Bungoma. Senator Wetangula is an opposition court principal, the only one in Parliament. But he might have to quit his seat if his detractors have their way. They argue that a Supreme Court judgment that agreed with earlier rulings that he committed electoral offences during the general election of 2013 should translate into the loss of his seat and exclusion from political contests. It should be a lively discussion on Cheche this morning because one of our panelists, David McCarley, contested the subsequent by-election that Senator Wetangula won. We also have with us our other panelist, Mutegi Njau. Good morning and welcome to the show.
Good morning.
So, your political future, it's hanging in the balance. What do you see as your political future?
I don't think my political future is hanging in any balance or at all, for the simple reason that what you're seeing in the media is a misquotation, misinterpretation, and misreporting of what the Supreme Court said. The Supreme Court actually did say that the finding of the Court of Appeal in Kisumu purporting to disqualify me from running in any election is quashed, and that is very clear. Then they said that their findings on alleged bribery be forwarded to the Speaker as is required by the law, Section 87(3) of the Elections Act, and to the DPP, which they have done. Then the Speaker is obligated under the law to gazette the finding. It doesn't mean anything, it's just procedural. What is important is this, that after the finding of the court in Bungoma, the judge himself made an unsolicited ruling that at no time did he intend or does the law allow him to bar me from any political contest, which is true. You can read the Constitution, Article 99, Article 103, and so on. Then he, as the law required, reported the matter to the Speaker and to the DPP. To the best of my knowledge, the DPP then instructed the Director of CID to carry out a criminal inquiry into the matter. The Director of CID carried out investigations and released a report that they had found me blameless, there was no evidence, and they opined that the file be closed. Subsequently thereafter, the DPP actually ordered the file to be closed. If you remember, and I don't want to ride on a bad example against my own friend, the day the DPP announced and ordered that the MP for Kitutu Cheche, Richard Onyonga, be prosecuted for allegations of not running his CDF properly, is the same date he announced that the file in relation to the Bungoma Senator be closed. We have clips from your studios, from everywhere, and the statement that he released. So I sit here, a most unworried person. I have no difficulty whatsoever in facing my future in politics. I have no difficulty whatsoever in meeting any challenges that may come the way, because the law is on my side, the Constitution is on my side, and the circumstances under which anybody can be disenfranchised in either being a voter or a candidate or both are very succinct and clear under our Constitution. If it is a situation of criminal responsibility, the Supreme Court itself said a court sitting on an election petition is not a criminal trial.
But
the standard of proof, let me just finish this point. The standard of proof in a criminal trial is beyond any reasonable doubt. Where a suspect is given an opportunity to rebut evidence in a trial, in a constitutional challenge to your election, which is a petition, is a civil matter. The standard of proof is a balance of probabilities.
Okay, let's just be clear, because I think we seem to be mixing up things. The Supreme Court said that an election petition being of a different kind in legal terminology does not necessarily constitute criminal proceedings, so that the burden of proof might be lower when you are facing an election petition, but higher when you're facing civil or criminal proceedings. And it directed the Kenya Law Reform, the Kenya Law Commission and various others to make the law clearer on what to be done when you have an election petition such as yours, because you were found guilty of an offense, right?
The Supreme Court did not make that finding in the manner you're saying it. It is what in law we call an obiter, a side issue to a judgment.
Yes.
And it comes at the dead end of the judgment where they say, in this regard, it will be desirable to notify the Attorney General, the Law Reform Commission, and the Speakers of Parliament to see how they can harmonize this law. But in the body of the judgment, if you've read it, they are very clear. This is not a criminal trial. We cannot ambush anybody in a civil court with a criminal matter.
It's not a criminal trial, but it doesn't exempt you from criminal proceedings.
It does. And you can just look at the findings of the court. Why the hell on earth would they furnish their findings to the DPP? Because they are aware of the fact that the DPP can then cause an investigation in a criminal matter and then prosecute where necessary or close the file as the case may be. That is the reason why the DPP comes in.
And the point you're making is that the file was closed?
As far as I'm concerned, the file was closed after the High Court proceedings. After the Supreme Court ruling, the DPP has been notified as a procedural matter. It is upon the DPP now to decide what to do. I have no difficulty facing any situation in law, in fact, in politics, because I know I am quite safe.
And would you, is it your opinion that there are attempts to revive this case?
Attempts to revive this case are quite evident. It doesn't really worry me. Of course, it's causing anxiety among my supporters, my constituents, and my coalition. But this is politics blending the law and the law riding on politics, okay, which I fully understand. We live in this country where, you remember, when Malcolm Wetangula disagreed with the late president, they went and dug up a case of an assault on his wife and sent him to jail. And we have many examples to quote. But to me, as an individual in politics, with a record of fearlessness and speaking my mind and not looking over my shoulder, I have absolutely no worry. I'll take it as it comes.
In your view, who is trying to revive this matter?
It doesn't need any rocket science to know who is reviving. The Jubilee system, I have no doubt.
Oh, it's Jubilee.
Well, you know,
I'm not saying there is Jubilee has many facets, and they have been talking excitedly about this matter in many fora. I don't want to speculate on matters that may come to a level where I need, if need be, to get myself to defend the position I hold. But I have no doubt that there is a very heavy political tones in the manner in which the matter is going. Because we've had Jubilee-leaning politicians from Western Kenya going around funerals, making all manner of pronouncements about the matter, which doesn't really rattle me at all.
I think, you know, I'm in a very awkward position, as you rightly pointed out, because the Senator and I, you know, have had a contest before. But we are friends, and I think we...
Don't worry, David, I've never seen you as a rival.
We moved on. But I think I have to really differ with what the Senator is saying. Right. And it's in my right to do so. I think the Senator tries to gloss over very serious matters in respect of that Supreme Court ruling. The Supreme Court ruling had a ruling with regard to the criminal offense of bribery, which it directed the didn't direct, which the DPP is expected to act upon. And it didn't go out of its way to make that ruling. In fact, it arose from the appeal that the Senator had filed right at the Court of Appeal. And so the Supreme Court was addressing a matter that had been brought before it by his own application. And so any insinuations that somebody else dragged it there or whatnot, I find it a little strange. But that's not important. Yes. My important point here is where I think the Senator is misguiding and misleading his supporters, my people, if I may, if I may say so, with regard to the election offense of bribery and the finding of the Supreme Court, and hence the directive that the registrar serve the Senate Speaker and the IEBC as well as the DPP, the notification. And what flows from that notice? The Senator is not addressing it. It is that the Senate Speaker is supposed to gazette the finding of an election offense having been committed by him. And what is the consequence of that? It is that the IEBC is supposed then to pick it up and remove him from the voters register. Isn't that the accurate law?
No.
According to the Elections Act,
you've missed
Section 87?
You've missed it, David.
What has he missed?
Correct.
The procedure is as follows. The finding of the court is sent to the Speaker, to the DPP, and to IEBC simultaneously. The Speaker of the Senate, or the relevant House, is supposed to gazette that finding. This all ends there. The IEBC, upon that gazettement, is supposed not to automatically act on the gazettement, but to consider.
Yes.
The consideration includes looking at the law, looking at the Constitution, looking at the facts, and reading the judgment properly. What does the judgment say? This is not a criminal trial. The standard of proof is different, and we expect that a procedure that leads to a criminal trial with all the safeguards, if you read that judgment very carefully, all the safeguards that are attendant to a criminal trial are addressed. So the IEBC is not mechanical. It's supposed to carry out a consideration. That consideration includes the right to a hearing. And the right to my hearing includes my right to go with my lawyers if we reach that stage. We can also end this matter at the level where the DPP reiterates his earlier decision that I found no culpability in this matter. The file is closed. The matter ends there. If anything is taken that tends to undermine my constitutional rights, then the same courts are there to adjudicate on it. So it's nothing like a seamless flow.
So contrary to your earlier position, your political future actually does hang in the balance.
It doesn't at all.
It does,
on the consideration. I mean, how does it not hang in the balance?
Right.
Yes.
When your name is due for consideration for removal from the voters register.
The
Which then would mean, for me, my interpretation is, I mean, obviously your term as senator is not interfered with, my reading of that as at now. But then the removal should take effect at the next election, which is where there is now lots of doubts being cast upon.
What you should read very broadly, and if you look at our constitution, it says this constitution shall be interpreted broadly, liberally. If you look at the constitution clearly, any finding of any person as being guilty of an election offense stops you from participating in a subsequent election.
But that's the point.
It is not a ban forever. Yes. In my case, what was my subsequent election? My subsequent election is the election that we contested with you. The by-election.
The by-election.
The election of March 2013 is the election out of which the election petition sprang. So let me finish.
Okay.
Out of which the election petition sprang. After the election petition, the subsequent election is the by-election. And if the court had barred the senator for Bungoma for running in the subsequent election, then I would have been ineligible to run in the by-election. That is the only subsequent election.
But you were eligible to run, just a minute, David, you were eligible to run for that election, though, because you'd already filed your petition at the Court of Appeal in Kisumu.
It was not predicated on the filing of the Court of Appeal. The judge, even before we went to the Court of Appeal, himself said, and I should have come with this ruling to read to you, he said, in my finding, I have not in any way, and I cannot do so in law, barred the senator for Bungoma from contesting in the by-election. All I have done, and the law requires me to do, is to notify the DPP to carry out an investigation and, if necessary, prosecute where an offense is disclosed.
But that is the law. But that is the law. The petition law does not mandate the petition court to bar anybody from contesting an election. That is why the order or the communication issues the DPP for further action, if any. And secondly, there is no way you would have been barred from participating in the subsequent by-election, because even the Constitution itself says no one shall be barred from an election until all mechanisms of appeal have been exhausted.
Exactly.
And
those
mechanisms have now been the Supreme Court.
Yes, they have now gone up to the Supreme Court. Doesn't that render then your next election?
At all. It doesn't.
Election?
What you should understand, David, and the whole panel, is a criminal process and a civil process are different. You can exhaust your appellate machinery in the civil process to where we have reached. If there was any criminal process to be started, it has to start at the magistrate's court. It will end up at the High Court if necessary. It will end up in the Court of Appeal if necessary. It will end up in the Supreme Court if necessary. So what I'm saying is that so that we don't overflog this matter, yes, is that I am the subject. My opinion counts as your program says. My opinion is as follows. I'm under no threat. My political future is not in the balance. I have no risk of being disenfranchised from either participating in elections as a voter or as a candidate or both. And I'm sitting pretty, looking to the future with absolute confidence.
Okay,
educate
me on this matter.
Yes.
The ABC is supposed to have done something. What have they done?
I don't know.
Okay.
That you can ask her.
Actually, the Senate Speaker is the one who is supposed to have done something.
Supposed to gazette it. And on the
Senate Speaker gazettes, IEBC considers.
Right. But on the basis
their
of
consideration then will lead to an action.
Yes, yes.
Sir, on the
that
basis
action,
of that,
if it undermines my rights,
there is something pending.
Is subject to any other court process.
There is something pending, and I want to pick up on that. Because somebody like David can say on the basis of the gazettement of the Speaker's report that you are unfit, given Chapter 6, to be Senator.
Not at all.
Not at all?
The Chapter 6 findings and provisions, you can read the Constitution Article 103 or 104, have absolutely nothing with these proceedings. And these proceedings have no relation with Chapter 6.
I beg to differ on that.
Chapter 6 is different.
The Court of Appeal.
And I can tell you for sure, first of all, the findings of the Court of Appeal that purported to disqualify Weta from running in any future elections was dismissed and quashed.
Yeah.
That means that nobody can vary, can move away from that finding of the highest court in the land. That any attempt to disqualify Weta from running in any election is hereby dismissed.
Okay.
What other clarity do you require?
Yeah, what I'm saying is that, well, the Court of Appeal had quite a mouthful to say about the allegations of bribery, which the senator was accused of, and it went into depth to say whether, in fact, somebody who has been accused and found to be culpable in a bribery matter can be said to have integrity under Chapter 6.
And that has been dismissed by the Supreme Court.
I think it's the finding to buy you that was dismissed, not necessarily the entire. But that is. But
I have read that judgment. David, I'm a lawyer of 34 years standing. I have read that judgment painstakingly to the extent that there is not even a comma. I have not paid attention.
I can imagine.
And I can tell you that I have not been reading just as a lawyer, but as a party to the matter.
Yes, yes, absolutely.
And I have not just read it alone. A team of more than 12 lawyers have gone through that judgment, analyzed it, reanalyzed it, assessed it, and come to a finding that it portends no threat to me.
Right. What has not happened here is the gazettement by the Speaker, which this ruling was made in June or thereabouts. Why hasn't the Speaker moved to then clear all these things around you so that we...
Even if the Speaker gazetted that ruling, that is purely procedural. The next level of play is IEBC, which do not have an automatic action. They have to consider. And you may be invited to look at the Michael West dictionary on what the word consider means. And it will help you to understand what IEBC is supposed to do.
Okay, we have to take a break now. This is Cheche. We're live on Citizen TV. Today's guest is Senator Moses Wetangula, Board Principal and Chairman of the Ford Kenya Party. Do you think he has a political future? SMS us on 22422, or you can tweet us using the hashtag Cheche.